right, you won't. So let's move on to immigration enforcement, which is kind of why a lot of people I know had logged into this webinar, because enforcement has been sort of touted, especially since President-elect Trump has one of the major pillars of his immigration action. According to the new administration, immigration law enforcement is one of the priorities, and particularly in the workplace, the goal is to focus on employers rather than workers. So this is my sort of plug on the media. There's been a memorandum since 2009 about amping up enforcement against employers. And believe it or not, enforcement against employers has been huge this entire time. It is translated to the most civil or administrative arrest of individual employees. And we've seen changes and a lot of shifts with employers. So if you think you're going to see something different, and if you're in the service industry, you've already felt this, it's just going to probably get worse. So that's why if you didn't get everything in line now, let's talk about it.
And we're not trying to intimidate you or make you feel afraid of what am I going to do from now on. We're just trying to bring some information and attention to this so that we can help you to get ready and at least bring your I-9 forms into compliance.
Right, because this is something that, like, with new hires, it kind of gets pushed to the bottom of the priority list. And so now that we keep hearing enforcement, let's sort of take a look at it, examine it, make sure some policies are set in place for the company. So when we talk about enforcement, who are the key players? ICE, Immigration Customs Enforcement, they're like the police agency police arm of the agency. Department of Labor has a memorandum of understanding with Department of Homeland Security, and that memorandum of understanding talks about how they can both enforce these same laws, these same rules, and a lot of people don't talk about DOL enforcement of it, but it's out there, and it really is. I think that's going to be part of the shift that we're going to see. Again, with Department of Justice, Office of Special Counsel, Department of State, states and municipalities. So you have a lot of people that can peek in to and take a look at these I-9s, and that's a major reason why you want to take a look at them. So how does enforcement come about? Money, civil fines. There are criminal penalties, and again, I'm not trying to scare anybody, and we'll get to that, but really the civil fines are going to be where they hurt. And because we saw the increase in fines last August, they are certainly more punitive than they ever have been. Debarment from government contracts. Now this is going to affect our construction industry folks and folks who basically are bidding or trying to do sub bids for these contracts. You could be debarred. So, you know, are you going to cut off that source of income? A court order requiring payment of back pay to the individual discriminated against. So, going back to what Angela mentioned, you're requiring everyone who says they're a U.S. citizen that you may not think is really a U.S. citizen and telling them to bring your passport. Guess what? You're discriminating, and while you may think you're being very thorough, an individual could bring that to the attention and of one of these prosecuting, and there you go. You have a court order to pay back pay. What do these civil penalties look like? So I don't have the old ones up there, but they were $110 to $1,100 for the first offense, and so now you look at the first offense, I-9 substantive violations is from $539 to $4,313 per offense. Okay, that's pretty steep. The I-9 technical, sort of the paper violations, those are at least half, but you're looking at $216 to $2,156 on the I-9 form. So these mistakes, as you can see, just from what little we have here, and the full list of civil penalties, we can provide that list, but these are very steep. Now, the reason, or one of the reasons behind sort of these steep, besides the fact that they hadn't been increased in years, was the talk among service industry, particularly in construction, that these businesses were functioning with sort of these I-9 possible issues, these civil penalties as a cost of doing business, which was very interesting. So if you had a construction company that said, look, we kind of have worked this in that if we were to get hit with an ICE raid and lost, we've buffered in to how to be, we could cover that cost and continue the work of the project. So now with the steep increase or hike in these violations, the idea is that they're really trying to go for a punitive, something that will really hurt, so to discourage unlawful employment. The next slide, civil penalty. So false statements, misusing visas and identity documents per document. These are, again, stiff penalties, and you're looking at, there's administrative ways that you can be imprisoned in the criminal ways. The criminal is probably the one that we've seen. I don't know if everyone remembers, there was Tyson, there was a couple of other highly or heavily immigrant workforce driven industries and companies where they found that these hiring managers and these supervisors were engaging in a pattern of practice of recruiting or referring for a fee these unauthorized aliens. So they are going after these individuals, and these are fines up to $3,000 per employee and or 6 months of imprisonment. So again, nothing light, nothing that's very easy. Criminal charges are serious, and we want to see who could be charged. I mentioned business owners, plant managers, and supervisors, HR personnel. So who knew that working in human resources could put you at risk of going to jail? But if you don't have these policies in place and sort of have a really good oversight, especially for these larger organizations, this is what you could be facing. And that's why, again, not trying to scare you, but sort of trying to push anybody who's been sort of pushing this to the bottom of the priority list. It's maybe now in 2017 as part of a New Year's resolution to kind of get these things in order. Union stewards, intermediate senior executives, accountants even. That one was very interesting. Okay, E-Verify. We talked about it at the beginning. E-Verify is a whole different topic. But if you must know, yes, E-Verify for continuing to employ those whose work does not match with the DHS and SSA records. You've gotten these notices in the mail. That's what you're looking at, $751 just for the low end of that fine. And again, federal contractors, debarment, you just don't want, if you're in construction, you don't want to have that, because I understand a lot of them come from these federal contracts. If there's going to be a hike in federal contracts for, especially down here in Texas, for building a wall, you're not going to be able to participate in that contract.
In that wall.
You can't do your work for the wall. So, moving on. Anti-discrimination violations, document abuse. So, this is where I've seen historically a lot of HR, especially generalists or folks who are starting out under your senior HR managers, they're sort of tasked with this duty, and they don't really understand the list A, list B, or C. It's pretty self-explanatory, but again, you need to be reminded to kind of look at that and make sure they're not saying, you know what, just bring me your social security card and driver's license and we're good. Or just bring me your green card and we'll be fine. That's all we need. You give them the option. You do not want to be hit with document abuse. Document abuse also goes into where if they were to pull all the I-9s, there's a trend there that some documents are kept for some employees and not for others. Again, unnecessary fines, things that could be avoided if good policy is in place for your company. Let's see. So how are enforcements done? So the most publicized ones are the worksite raids, or the less publicized one, just the visit. The visit's benign. You get an officer who comes up.
Very friendly, by the way.
Right, very friendly. Hi, I'm here to speak to so-and-so. Are they available? I'm here with ICE, or, give them a card, and then the panicked receptionist tries to find who and where and what to do. This needs to be cleared up with whoever is going to be manning your office or front desk, because you have to know how to handle these things. The other ways that are going to, you're going to see this sort of enforcement is by inspection. typically delivered through a warrant or an administrative subpoena. So depending on the investigative agency, whichever one is initiating the enforcement action, will depend on how you sort of see this enforcement action take shape. And why is it important that we have a policy in place? Because of the cost of responding to an audit or administrative subpoena. This is not just talking about the fines that we kind of briefly touched on. We're talking about the cost of personnel. If you didn't ever separate I-9s from all personnel files and you just kind of kept them all there, now how much time is it going to cost, or how much in terms of salary, hourly employees, or your time to come out there and start going through boxes and boxes of and pulling out these I-9s? It's going to cost you in wages, in time, headaches, and not to mention the ultimate fine. So this is why we impress upon you the need to sort of get this thing that's normally at the bottom of your list up to the top. So to determine this amount of the penalty, ICE has enumerated factors, and the size of business, good faith of the employer, seriousness of violation. You can read them all there. Those are the factors that they're looking at. And it's important, size of business is going to come into play. Typically, traditionally, 100 employees or less is considered a small business. So good faith of the employer, I'm going to touch that in a minute. Good faith as in good faith prior to the audit. Good faith post-audit and post-actions is sort of the expected. It's what is supposed to happen. So they're kind of looking a little bit, they're looking back and not so much forward from when they came over here to check what's going on. Whether the employee was authorized to work and employer's history of violations. Now, the construction companies I've worked with in the past, both of them had 100% I-9 compliance. But upon further review, 64 of those employees were unauthorized to work. How does that happen? Documents look reasonable. All forms are done absolutely 100% accurately. This company, on a yearly basis, has an outside counsel, or with my office at the time, come in and do the audit. So yes, you could still be 100% compliant and not have employees that are authorized.
But that's part also of compliance, and that's what we're going to be talking about in our second webinar, because not necessarily because you have 100% compliance and 64% of workers work with authorization. It means you're going to be criminally charged and heavily fined, because you might have good defenses. You didn't know.
Right, and to highlight on that example, the documents were reasonable. Please, please, please do not underestimate the valuable source that is the M274, the Handbook for Employers for I-9. That is a PDF. You can go on their website, refer to it all the time, and it's a good source to have your HR employees kind of go back and overview to see. They have examples of the documents.
And we'll touch bases on that in our next webinar, and we'll show you where you can find that handbook, which everybody who is in HR should have by their desk.
Exactly. So the good faith defense, as I touched on briefly, it's compliance with the I-9 requirements. Once you can show good faith, you're not going to be in that camp of knowingly hiring unauthorized aliens, and that is critical, because now you're not dealing with so much criminal liability, and nobody wants to deal with that, at least not when you're at work. Good faith attempt to comply with I-9 requirements, such as self-audit, is a mitigating factor. Well, because of this particular point, we're going to be doing the following webinar. The self-audit is tricky, though, because you're auditing, and if you're making mistakes, you're not necessarily catching the previous mistakes. So it'll be ideal to bring in a separate set of eyes, but still an attempt can be a mitigating factor when you're facing an audit.
Because they'll see, the agencies will see that you really tried in good faith to correct the mistakes, and that counts.
It does. It definitely does, and time again, as I mentioned in the last case, that was one of the huge mitigating factors. So, responding to government inquiries, again, this will be fleshed out because of time separately later on, but when you choose one person as a point of contact to correspond with ICE, it's critical. That is going to be your internal person typically it's going to be your senior HR executives. You do not want to delegate this to your newer HR generalists or employees. You want to delegate this to somebody or take it on yourself as a manager to sort of be the point of contact. Know your rights as the employer when you're facing or face-to-face with this ICE officer. Request to see the documents that that they have the right to search the premise and talk to employees. There's no warrant. They need to give you a card, and you make a copy of the warrant, and you get on the phone with your attorney. There is no reason anybody should be allowed to speak to your employees unless they have a warrant. Particularly, they have no warrant. ICE agents must request permission to visit and interview employees. You don't need to allow it. I don't care how mean or ugly they're being. I don't know what threatening words they're giving. Know your rights, protect your employer, act in the best interest of your company.
Yeah, but and just keep in mind that not always, and usually these agents are very nice and very friendly. So you kind of get engaged in a nice, friendly conversation, and all of a sudden you're opening your books, your doors, and they're talking to everybody in the company, and then you have a huge problem in your hands. So not because they're friendly, not always they're threatening with, I'm going to call the police right now. No, but most of the time they're so friendly that it's hard to tell them, no, you can't. So keep in mind that.
But you can tell them no.
You can tell them no.
Yes.
And you should tell them no.
Right. And again, for the senior executives, this is part of your fiduciary duty to the company, which is why this is a critical component. Ask about the purpose and scope of the inspection. Once we get through the weather and how everything is going so well, maybe a little chit-chat about the new administration.
Even coffee.
Right, even coffee. What is the purpose and scope of this inspection? What are you looking for? And Angela's experienced, obviously, nicer officers than I have. But generally speaking, don't let them walk around. Oh, can I just take a look? This is a great facility. Or, oh my gosh, what do you make here? You're so proud of your company. Oh, well, let me take you back here where we make this part of this food or whatever. Oh, you want to check out the kitchen? This is where the magic happens. No, do not. This needs to stay in a conference room or an office or in a corner booth of the restaurant where it's very clear and we can exchange the paperwork. Don't let them walk around. If they need to go to the bathroom, I've had somebody that walked them to where the restroom was and kind of stayed there so that they didn't lose their way getting back to the front.
And believe me, you can do that. Okay, just don't go in the bathroom with that.
Right.
You can wait at the door.
Okay, and with everything, especially if you're in a panic or you're not in the office and someone else is saying, hey, ICE is here, what do I do? Make copies and make sure you have the policy in place to only comply with the information. And you can tell them, look, I need to get this to legal counsel. You don't even say you have to call your immigration attorney. I just need to, you're delivering a warrant. You understand I have to have our legal counsel look at this. And they should and they will respect that. Let's see. Okay, do not waive your 3-day notice right. Well, no, sure, I have the I-9s right here. I know exactly where they are because we just did a self-audit and we were very prepared. Do not waive that right for your 3-day notice. They are required and you can waive it, but why do that? As an attorney, anybody will tell you don't waive that. And sometimes, especially for these larger organizations, you will need to ask for an extension because it will be incredibly difficult when you look at the scope of what they're looking for to possibly put together all the requested I-9s because they're not going to often just request I-9s. They're going to ask for additional documents that are sort of separate. For example, payroll records, list of hiring dates. And all of this is going to go back to see if you did, in fact, complete the I-9 accurately.
And often they do list the dates they're looking for, but don't think they're gonna say, well, we want information from January 1st, 2017 to January 30th, 2017. No, they go back years. And you have to look through records for many, many years. And there is what is so important to do away with those I-9s that you don't need because you don't want to give it to them if you don't need to.
And pay attention. That's a good one because I had someone who forwarded all the I-9s when they could have purged, I think it was like 24% of them. But guess what? Once you gave them to the government, you're on the hook for those mistakes. You couldn't come back and be like, oh, you know what? I just saw that I missed the purge dates.
20%
Yeah,
of those. No.
I need those back. Because no, you submitted them, and guess you're going to be on the hook for those violations.
Mm-hmm.